Good morning, everyone, and welcome. The hearing today is part of the process of considering submissions to the proposed Gore District Plan. My name's Keith Ovell, and I'm Chair of the District Plan Hearings Panel. Other panel members are Maria Bartlett to my far right, and Glenys Dixon, and to my left, Cliff Bolger. Today we're considering submissions lodged to the Natural Hazards chapter of the plan, although issues associated with natural hazards have been raised in a number of chapters throughout the proposed district plan. Today we're also giving further consideration to earthworks issues. We have read all of the pre-circulated material in preparing for today, and we don't need to have this reread, but we do ask for a brief introduction summarising the main points. I'd like to indicate at the start that a key matter we'll be working through today is the issue of scope, not only with regard to outcomes sought by submitters, but also arising from the reports received from advisors to the hearings panel. I don't want to curtail any legal submissions, however I do flag we have previously been made aware of the case law on this matter, but we will have some questions relating particularly on the mapping issues. In terms of the proceedings today, we'll hear initially from Stony Creek, then the advisors to the hearing panel and Environment Southland, taking us through to lunchtime. Our timetable shows Environment Southland after lunch. We'll just have to see how that progresses. And then later today, Federated Farmers. Then we're back tomorrow for the telecommunications companies, Kiwi Rail Alliance and the reporting planners. The hearing is streaming live, and I see that we've got some people tuning in to us on the Council's Facebook page, and it's available for viewing at any time. When the panel's deliberating, we may review that recording. The volume of reports and evidence we've received for this hearing and the fact that it relates to a number of other hearings means that please, you may need to be patient with us as we move from one document to another. The people present are generally aware of health and safety issues. If there is an event, we meet on the footpath on the opposite side of the road outside the front of the council, and the toilets are in the hallway past the rooms behind me. We have a new advisor with us here today, so it's probably appropriate we have some introductions before we commence with Stony Creek. Brett, introduce yourself.
Good morning, panel. My name is Brett Osborne. I'm the author of the Section 42A report.
Thank you. So, Brett, do you want to come up, and I gather your team's online in your hands.
Yeah, good morning, Commissioners, and thank you for the opportunity to speak to you once again. As you know, my name's Brett Heisted, representing Stony Creek Station, and online here we have Mrs Claire Perkins, our planner from LandPro. Mrs Perkins has provided a response to supplementary evidence X minute 27, and she will speak to that response. Before she does, just a couple of comments from me, as you probably would expect. Farm fencing and associated activities should be exempt from earthwork rules as per our submission. We're yet to see evidence of an RMA problem that exists and needs to be addressed. And in terms of the Hokonui Hills, a significant effort was put in by two landscape architects reaching an agreement within the NFL chapter. In the absence of geotechnical problem that has not been evident for the last 100 years, we'd seek that the NF rule should apply and sit in that chapter. And lastly, panel, it is critical that unworkable limits are not imposed on the farming sector. So at this point, I guess I should hand over to Claire, who's going to speak to her evidence.
Claire, before you speak, if you can just wait a moment until we all bring it up in front of us. Thank you. And also, we're told that you're mute at present. I'll come back to you in a moment. Thank you, Claire. When you're ready. And sorry, Claire, we can't hear you. Do we have an issue at this end or the other end? Tina, can you speak for, can we hear you? No, so the problem is at this end. So we'll have a slight delay while we sort that out. Claire, can you try speaking now?
Can you hear me now?
Yes, thank you.
Perfect. I was slightly concerned that there was something wrong with mine because I did have an issue last week, but I was like, well, it's flashing its little bars showing that the speaker's working at my end, so I'm pleased it wasn't mine. Claire Perkins from Landpro, Principal Planner. You've had my sort of background a number of times now. I guess I wasn't going to say too much and really just kind of like emphasise the points that Brett made with regards to the response to minute 27 from early February. Mainly being that the key issue, I think, well, one of the key issues, and you raised it earlier, Commissioner Havell, was around the scope, and I think that's where there's a difference of opinion between myself and Ms Carson McColl, particularly with regards to the relief sought for fences. So the relief that Stony Creek sought in their submission was that at that time the rule sort of said that it was for the disturbance of land. It didn't actually say the word earthworks. However, it did actually contain rules that were limits that were earthworks limits rather than just land disturbance limits. What Stony Creek sought was the deletion of any limits that had controls on width or depth or height, and simply that earthwork standards 3, 5 and 7 were complied with, which relate to setbacks from streams, erosion sediment control and accidental discovery protocol. My view is that the relief being sought for fences is entitled to change slightly from what was in the submission, particularly because the Section 42A report has now made significant changes, recommended significant changes to that rule, namely that the Section 42A report has now added the word earthworks into that rule heading, as well as requiring compliance with standards 1 and 2, which have limits on depths and slope and cuts. So I think my view is that the relief sought by Stony Creek is in scope of what they originally submitted on, particularly with the changes being proposed. However, when I have further looked at the scope for the relief sought for fences, that's possibly a little bit more challenging because the relief sought didn't actually make any take any issue with the area at the time, but probably just from a number of provisions that had to be looked at and not having been in them as deeply as we have now to actually understand the implications. But except that's something you will need to look at further. But I do not believe that the scope for fences is an issue in terms of the relief being sought by Stony Creek. Then in terms of the provisions and what's sort of being the approach being taken for fencing, I have had quite a deep look at the Section 32 report, and I don't believe that it actually realised or looked at the issue of fencing for farmers. The costs for consents, the one mentioned in the effectiveness and efficiency and costs and benefits table, was in relation to developers. There was no real consideration of fencing for farmers and no real discussion of whether there was actually any issue arising currently on farming and farming activities in relation to fencing in particular. I still don't believe that there's been any further information to support that there is actually an issue occurring, and I think you've heard from Mr. Heisted this morning that they've been doing this for 100 years on the farm and haven't had any issues with land stability occurring. in addition to that, my view of the policies is I accept Ms. Carson McColl's comments that they need to be read as a whole, and when I read them as a whole, I read the earthworks objective stating that we need to facilitate earthworks in a manner that minimises adverse effect. Policy 1 recognises the benefits and necessity of earthworks and seeks to enable those, particularly those associated with primary production. And then the next most relevant policies, 2 and 3, are not really too relevant because they relate to the national grid and areas subject to flooding. Policy 4 and 5 I've highlighted in that response to the minute in my paragraphs 13 and 14, and note that they primarily focus on the issue of amenity and stability of other sites, ensuring that people and property are protected, and making sure they don't exacerbate any other natural hazards such as land instability on other sites. So I think my view is still that fencing is limited in its scale and activity inherently. It's not like general earthworks where you may need to have a limitation on the volume or the area because it's an activity that can occur over such a wide scale. If someone was undertaking earthworks that were clearly not linked to a fence, there would be the ability for compliance to take action in any case. I probably don't have too much more to add to that, and really rather just wait for your questions to discuss that further. I accept that this is probably still something where there's quite difference of opinion still between myself and Ms. Carson McColl on the planning approach.
Thank you. Before I open it up to the panel, I should highlight that I'm not part of the panel making decisions on the earthworks, but as you've highlighted, there's links to other chapters in the plan. And I guess one of the overview things that as a panel we're looking at is you've highlighted note 1, the provisions in other chapters, and it appears that the lists are getting longer and longer in terms of the other chapters that need to be looked at as part of these provisions. And I don't know if you've got any thoughts on how best to deal with that to minimise it, but yeah, give you the opportunity for feedback.
Sure. I mean, my view, as I've noted in that response, is that I think the earthworks can be covered where there's a specific overlay that deals with a number of activities. So in this case, my recommendation is that the exemption can apply, as it kind of has done in the draft, in the notified plan, to say that the natural features and landscapes chapter can cover earthworks provisions, and based on my recommendation for fences in particular, that there doesn't need to be any other controls other than those recommended in the NFL chapter that would sufficiently control those. There is a lot of overlap with some of these chapters. Whatever it lands on, it just needs to be really clear. But I think, yeah, I think it's easier for a lay user of the plan, I guess, not a planner, to have it really explicit and not have to go between 5 or 6 different chapters for the same activity. And if they've looked at one chapter, understand there's a book in the other chapter. There is also an issue with the limits being different between the two, but I don't think they're that far apart in terms of the earthworks depth being sought.
Thank you. Glenys, any questions? Maria.
I think you've laid out your position really clearly, and I just don't have any questions for you. I understand what you're saying and why you're asking for what you're asking for, so kia ora.
And in part, I guess that's a reflection of the amount of time that we've actually spent on it to date, and the minute was issued and the responses received. So Brett, anything else from you, or we'll let you get on with your day?
Thank you. No, nothing from me.
Cheers.
Thank you.
Thank you. So our timetable shows a bit of a gap until we're ready for Environment Southland, and I see we've got Marcus up the back, and when your full team's here, put your hand up and we can proceed. But in the meantime, it's an opportunity to hear from the planners unless I'm told to the contrary. You ask her. Oh, yeah.
Kia ora, Ms Carlson McCall. I thought it might be a good opportunity, since you're with us online, to speak to your right of reply, following on from us hearing from Stony Creek.
Yeah, sure. So I had raised the issue of scope, and as you've alluded to, Ms Chadwick has provided a legal submission in relation to that, and I believe she might be speaking to that tomorrow. My point mainly in relation to Stony Creek scope is that what they submitted on in relation to fences was a little bit different from what the position they're holding now. But I'll leave that up to the panel and Ms Chadwick to make a call on. I have made my position clear on that. In relation to earthworks management issues for fences, it's not so much that the earthworks chapter is specifically trying to control fencing, it's trying to enable it, and that's why there is no volume controls on it. But when the rule, because the rule was made more enabling, it was previously for the notified version only land disturbance, and it had relatively restrictive scale limitations as condition 1 and 2. And through the 42A, the rule was made more enabling. Earthworks was brought into it, but therefore all the earthwork standards also are recommended to apply. And the reason for that is more to do with earthworks effects than actual fencing. So it's trying to enable fencing, but manage earthworks effects. So yeah, it's regardless of the purpose of earthworks, it's the effects that are sought to be managed. The farm tracks are also sought to be enabled, and that's why they have potentially a bigger area and volume limitation than other general earthworks. So there are already measures in the earthworks chapter to seek to enable these activities. The recommendations have been consistent with expert advice in relation to being able to enable the fencing more, and the cut depth and batter slope standards are consistent with existing restrictions from the bylaw. And my position on this matter hasn't changed, but yeah, happy to take any questions if there's anything you want further clarification on.
No, I think our choice is laid out before us quite well between yourself and Stony Creek. Like our envelope for decision, I think we have all we need to make a determination. I don't have any further questions. It was more an opportunity for you to highlight anything you wanted to from your right of reply, and so that includes anything you might want to highlight in relation to infrastructure as well, because that was part of your response to the minute too. So you're welcome to highlight anything you'd like there as well.
Oh, thank you. Yes, so so there was 3 parts to the minute 27 response, and the first had to do with the national planning standards, and we've touched, Councillor Hovell has mentioned note 1. So the approach to it has changed a little bit. So the first approach was to have exclusions within the earthworks chapter, and the intention with that was to draw plan users' attention to that there's potentially more restrictive rules, often in relation to overlays, such as works within a heritage setting, and works within a landscape overlay or a significant natural area. So that was the first approach, and I've recommended that we change that and have each chapter to stand on its own legs. In my opinion, it makes the rules more complex when there is a lot of cross-referencing. So if the natural features and landscape chapter have to cross-reference into the earthworks chapter, and matters of discretion in the heritage chapter has to consider earthworks effects. In my opinion, it is clearer if the chapters work in concert, and that way the earthworks chapter can solely focus on the earthworks effects, and the natural features and landscape chapters can focus solely on those effects, and and they all work together. And I appreciate that it is a change from how it was, but I do think that this is makes it clearer. It's more consistent with what a lot of other plans are doing. And the direction from the planning standards in relation to this is not really clear. A lot of plans do different things. So it's trying to pick up on a couple of commonalities and go with them. You can, of course, have the cross-references. It works the same if, say, if you're undertaking earthworks within an overlay area and there are conditions in that rule that trigger the earthworks rules, that works as well. So it's more a different approaches, and what is most clear, what's the easiest for plan users. Really, it's administrative. It should have the same outcomes.
I think it was really helpful to have that analysis across plans around the country. I certainly found that really helpful in your reply to the minute. I think it's given us a good sense of where we can land. And as you say, there's a bit of variety out there.
And one of the issues we face is that we're dealing with a paper copy, but at the end of this process it's going to be in an electronic form, and that gives far more scope in terms of the way that links are provided from one chapter to another, so that if there's some rules in earthworks that are similar to or relevant to what's in other chapters, then a link is able to be provided. It's a matter of how we do that on the paper copy in the meantime. So thank you for that. I think, Maria, was there something else?
It was the two things, national planning standards and earthworks, so just an opportunity if there was anything further you wanted to say on infrastructure.
Yes, there is obviously, I have recommended two different versions of the chapter for consideration. My understanding from the submissions that have been is that there's more support to go with option A, which is my preferred option as well. It simplifies the chapter. The same activities should still be enabled or managed or avoided. It is, in my opinion, a more streamlined chapter and hopefully easier for plan users. The previous approach was to name the activities sought to be enabled through the rule framework, and they link back to that policy one. But equally, those activities are enabled under the catch-all rule. And yeah, I do think there's advantages in simplifying the chapter.
I did, when I was reading through your response on the infrastructure, it did throw up the definitions issue and whether we're talking about regionally significant infrastructure or critical infrastructure, the different ways that the terms are used in the plan. So after reading through the minute and doing a bit more myself, I did pick up that there were only 3 instances in the plan at the moment where regionally significant infrastructure is used, and that would tend to suggest that maybe that term is one that could be left behind in favour of critical infrastructure. So I worked through your minute trying to untangle really what was different between the different terms, and whether we can rationalise some of the terms. So again, it was helpful to have your response just to work through that. But do you have a view there about leaning on the definition in the plan for critical infrastructure and letting go of reference to regionally significant infrastructure?
That might be more me with infrastructure. Yeah, I think I have favoured the use of critical infrastructure. I know if there was a more succinct definition of regionally significant infrastructure within the RPS, then that might be something we would favour, but in lieu of that, I think, yeah, my preference is critical infrastructure, but I'd need to kind of review the individual times we've used regionally significant.
Well, it's funny you should say that, because I think that is, yeah, that's where I began, like just a basic word search at the notified version. Where was regionally significant infrastructure coming up, and it only came up 3 times. I thought, well, that's suggesting to me it's probably not the favoured term, and we need to do some rationalisation. So
yeah, I'll do a bit of a quick search in the break and come back to you later, but I think somewhere in my 42A it's been discussed, but I just wrote it a while ago. So
yeah, no,
I need
that's
to
right.
refresh my memory.
So, but thank you, and sorry, I was directing my questions to the wrong place. But, you know, we have more than we had before as a consequence of your response to the minute, so we appreciate that. So was there anything you wanted to highlight in addition?
No, happy for it to be taken as read.
Anything else? No. All right, thank you, Tina. That's all from us in the meantime. So that then enables us to pass over to Brett on his first trip here to the panel today. So a bit of an overview of the report, but before you start, your report's taken a slightly different format to other reports we've had in the past. And so, yeah, forgive us if it takes us a while to jump between the different things. What I wanted to highlight, though, in your Appendix B, and I'm looking at a numbered page that I think is number 21, and there's 3 further submissions that are listed there from Contact Energy, and so the reference for one, when you look it up later, is FS 24.027, and there's a couple that follows. Appendix B is extremely important to us in terms of the process of deliberating and writing decisions. There are 3 further submissions lodged there, and it is not clear which submissions they relate to. So can I please have another copy of Appendix B that actually shows the further submissions immediately after the submissions?
You've caught me on the hop there, so I'll need to clearly have a look at that and just follow that alignment that you're referring to. So really your question is those 3 further submissions?
Well, it may be elsewhere in the Appendix B as well, but they're the ones that jumped out. So it's important for us to be aware where there's further submissions to submissions, and with them grouped together there, it's not clear which submissions they relate to.
Right, okay.
So just to clarify, you're not sure that they relate to the submission above that being Transpowers S101.042?
That's right.
Okay, we'll double check that.
So happy to receive from you an introductory overview of the report, and I guess after that there's probably a couple of key issues we need to work through.
Thank you. Thanks for pointing that out. We'll dive into that and have a look and come back to you. Right, good morning, panel. My name is Brett Osborne. I'm a planning consultant engaged to assist Gore District Council with the proposed district plan. I am the author of the Section 42A report, and I've set out my qualifications and experience in Section 2.1 of that report, so I believe we could take that as read. And although I wasn't involved in the drafting of the proposed district plan, and in particular the natural hazards chapter, I have read the Section 32 report and I am familiar with the notified chapter. Now the Section 42A report, I propose to take that as read, but I'd just like to provide a brief summary of the key issues identified through the submissions and the key changes that I've recommended arising out of those submissions. I have summarised those on page 7 within the executive summary. Effectively, they deal with directions for avoiding or managing natural hazard risk, other natural hazards, and predominantly infrastructure in terms of how it is addressed within hazard areas. The key issues that arose through the submissions related to the objectives, the policies and the provisions. They raised concerns around or sought amendments to objective NH03 around the approach in terms of avoiding subdivision and development within hazard areas, seeking a new policy to establish management criteria, amending policies to provide for hazard-sensitive development and identify specific levels of risk, specifically amendments to policies 2 and 3 regarding avoiding subdivision and development in unprotected areas at significant risk, avoiding all development within the Mataura River floodway except for critical infrastructure, amending rules to exclude sensitive activities from being established on flood-prone land as a permitted activity, preventing any new zones or ability to intensify within existing areas that are subject to natural hazards. An amendment was sought to Policy 4 within the subdivision chapter regarding its approach to avoiding subdivision in medium, high and significant hazard areas. Additional policies to address wildfire risk were also sought. And in relation to infrastructure and natural hazards, amendments were sought to the objectives regarding all hazard areas for infrastructure. Specific exemptions were sought for KiwiRail and telecommunication providers within the natural hazard chapter. An ability to distinguish critical infrastructure from other development due to operational need or functional need was sought. Amendments to objectives and policies to ensure objectives do not result in adverse effects on critical infrastructure. Excluding infrastructure from the rules controlling development in hazard areas. A new permitted rule for unoccupied farm buildings was sought within the flood layers, and a precautionary approach to liquefaction risk. Finally, amendments to the provisions wherever possible to recognise potential effects of mana whenua interests. So quite a few amendments and submission points were raised. And that probably explains the slightly different tact or layout within the 42A report in terms of trying to address those, because we're talking about a fundamental level from objectives and policies and then the provisions that align with them to achieve those outcomes and align with the identified overlays within the plan. As a result of the submissions, I made a range of recommended changes. Now, one of the key submissions was from Environment Southland, and it raised concern around how permissive the chapter as notified was in relation to natural hazards, and it sought the amendments to improve consistency with the RPS. My amendment sought to achieve that consistency in a better way. I've set that out in some detail, and I'm happy to sort of take more specific questions from the panel as we go through it. But for now, I'll just cover a sort of a brief range of amended changes. So I recommended amendments to the objective NH03 to better align with the RPS policy direction. Amendments to objective NH04 to clarify the intended outcomes through the use of defined terminology. Amendments to policy P2 to refer to the stop bank protection area because it wasn't included previously, and to clarify its policy direction. Amendments to policy P3 to refer to the actual and potential inundation area and distinguish the level of risk to activities. Adding a new policy direction regarding avoidance of subdivision use and development within the Mataura River floodway. Amendments to policy P6 to improve alignment with the higher order direction and matters of concern to Manawatu Whenua. And amendments to policy 4 within the subdivision chapter to align with the RPS policy direction. There were changes to the rules that I've recommended. A new rule to permit construction of non-habitable accessory farm buildings within the actual and potential inundation area. Amendments to Rule 2 to permit extensions to buildings within the actual and potential inundation area and the stop bank protection area. A new rule for construction of new buildings for sensitive activities within the stop bank protection area. A new rule for construction of new buildings within the actual and potential inundation area, which distinguishes sensitive activities. Amendments to Rules 4 and 5 to exclude reference to critical infrastructure. A recommendation to remove Rule 6 and transfer those provisions to Rule 9 within the infrastructure chapter.
Just hold there for a moment. Thank you.
Thank you. Amendments to Rule 9 within the infrastructure chapter to include reference to the actual and potential inundation area and the stop bank protection area. An amendment to the hazardous substances policy, policy 1, regarding significant hazardous facilities within flood-prone areas. And a note exempting natural hazard provisions from applying to regulated activities under the NESTF, that's for telecommunication facilities. I attached as Appendix A a strike through of those amendments to my report.
The copy we are using is the one that was with your supplementary evidence.
Fantastic, yeah. So turning to the supplementary evidence, following the release of the Section 42A report, Council received 3 submitter statements advising acceptance of the recommendations within that report, and 5 briefs of evidence from submitters seeking some further changes to the recommendations within the 42A report. I've summarised those within my evidence on page 1. So following a review of the submitter's evidence, I've prepared my supplementary evidence based on the further requests that were made by submitters and made some further recommendations for changes. Just before I touch on that, I just want to touch on some corrections to my 42A report, just so that the panel's clear on some corrections that are required. So there are 5 identified corrections. These are addressed on page 2 of my evidence, and I've included those amendments within Appendix A, which is the appendix I believe you're referring to.
Yeah, so if they're in the updated Appendix A, there's no need to take us through them. They're in front of us.
Fantastic, thank you. There's also one further correction I'd like to make, and it's regarding to my evidence in relation to Rule NHR2. That is my recommendation in relation to the evidence from Federated Farmers seeking a change to the setback standard of 20. You've come across it?
Yeah.
Fantastic.
So technical advice that you've been given that you hadn't picked up on.
Correct.
That changing 20 to 10 was quite acceptable.
Correct.
So you're
Thank
now
you.
acknowledging that that is appropriate.
I am acknowledging that, and I would like to update my my recommendation based on, to be consistent with that evidence, which is to reduce it to 10 metres.
And to help the panel, that's on page 5 of the version of the chapter in Rule 2, number 3.
And that's para 23 of Mr. Morris's evidence. So I would need to make a further update to Appendix A to reflect that change as recommended.
It's noted.
Thank you. I'll just take the panel just very briefly through my recommendations based on the more recent evidence in relation to telecommunication companies. The request in their evidence really boiled down to the note to be changed so that poles could be included. So all other infrastructure that is regulated under the NESTF is excluded through the NES, but poles are not. They're an exception. I've taken some further advice from Mr. Morris in terms of whether that would have any impact. Based on that advice, I have recommended accepting that further change so that all telecommunication infrastructure would be exempt.
What's in the evidence said you've gone too far in that if it's on private land, that's not covered by the NES.
Correct. It's a depending on who you ask, it's a quirk of the NESTF. So all cabinets, small cell sites, other telecommunication infrastructure under Regulation 57 is expressly excluded from having any natural hazards provisions apply to it. Poles are also excluded, but they break that down in terms of whether it's in a rural area, whether it's roadside, whether it's new, or whether it's existing. It does not cover new poles on private land in an urban area. So the telecommunication companies are asking that it also be grouped with all those other excluded items that would be excluded on an urban site on private land from the natural hazard provisions. So that's really looking at what is the effect of allowing that pole within that area in terms of, say, displacement of floodwaters or effects beyond the site. It doesn't affect any other consideration or provisions in the plan. It is just for the natural hazard provisions.
I was just wondering, with poles, quite often they have a large concrete base as well. So does that take into account that in a natural hazard area?
Yeah, it's a good question. I don't have any information in front of me at this stage in terms of how big a pole could be. So how big could these structures be in terms of it? The NES doesn't clarify what it is. So I think it would be a good opportunity for perhaps Mr. Tom Anderson to clarify what the scope of that could be. At this stage, based on non-technical understanding of what poles you would generally find in an urban environment, they are not particularly big. But on hearing further evidence from Mr. Anderson, that might be helpful in terms of determining whether that's acceptable or not.
So within the area subject to flooding, do the height rules still apply?
Yes.
So, yeah. So it's only the fact that it's flooded is the only issue that the NES is giving them an exemption for.
It's really just what is the impact in relation to flood hazards? Yes. Is it displacing water? Is it, potentially worsening the effect? And the advice from our flood engineer is it's unlikely to have a discernible effect. I'll just move to Alliance. Following further advice from Mr. Morris, I recommend accepting the request from Alliance to exclude non-sensitive buildings such as the meatworks from requiring a minimum finished floor level for new buildings within the actual and potential inundation area. That's addressed under Rule NHR6. Alliance also sought a minor amendment to Policy 9, NHP9, to expressly exclude critical infrastructure, which is consistent with the intent of that chapter and the policies within that chapter and the ability of the infrastructure chapter to address the rules regarding infrastructure and natural hazards. Federated Farmers.
Just before you move off that policy
Yes.
9, to me it would flow better if that policy actually said, with the exception of critical infrastructure, avoid subdivision, use and development within the Mataura floodway.
Syntax-wise, it would be, sure. Yep. Federated Farmers, we've addressed that requested change, and so I'll move on to Kiwi Rail.
Excuse me, sorry, I do
Yes.
have a question about that. I'm thinking about agriculture and silage and hay bales and things like that were swept down in the last flood, causing a lot of damage. So I'm wondering if that should be included somewhere in the rule or in the policies.
It's a good point, and there is an existing bylaw that deals with materials stored within the flood or adjacent to the Mataura River, and that's managed by Environment Southland, and that deals with storage of materials, baleage, any buildings or structures or otherwise.
Floatables, I think they say.
Yes,
Those,
yeah,
Right.
yeah.
Okay, thank you.
Shall I move to Kiwi Rail?
Yep.
So Kiwi Rail have requested specific exemptions from the provisions in relation to maintenance or protective works that would occur outside their designation, and in particular in relation to the rail bridge that crosses the Mataura River. There's no new evidence supporting the request, which was made within their submission, and I've addressed that within my section 42A. Based on Mr. Morris's comments in relation to that, it is a very high-risk area. It's not clear what the difference is in terms of preventing further works, but works within that area would certainly have potential downstream effects. So in my view, it would be appropriate for those effects to be considered if there are any works, earthworks or protective or otherwise.
There appears to be another reason, and that is that the bridge itself is in the bed of the river, and the district plan does not or should not control rules that apply to the bed of the river. So a consent may or may not be required from Environment Southland to actually carry out works within the river. And putting a permitted activity rule, we don't have the ability to do that anyway.
Thank you. I haven't heard that. It wasn't included in the evidence or the submission that I read, so...
Yeah, completely missed by everyone so far.
Right, so that's a jurisdictional issue.
Yeah. So we're only responsible for the surface of water in the river and the area above. So a designation allows a structure above the water, but any work done to remove the trees and the gravel from underneath fall with the regional council.
Yeah, and it will depend on where those works are occurring as well. So protective works, riprap, etc., could be occurring on the banks, you know, outside the riverbed as well. So, yeah. I should probably turn to Environment Southland's further evidence as well. So, the key, in a nutshell, effectively, the further evidence seeks embedding the ES model that has recently been released into the plan and further changes to the chapter in terms of its policy direction and provisions based on an interpretation or a reassessment of how to define significant risk under the RPS. So it's really an approach to unpack the RPS in terms of what it's trying to say, to an extent, because we can't change the policies within the RPS. They're beyond challenge. But it is turning its mind to what is significant risk and recommending that we approach that using hazard categories. In principle, I've signalled that I don't disagree with the approach. Using an improved model to identify depth and velocity flows is preferential. Identifying hazard risk categories is preferential, and building your policy and rule framework on that is preferential. The constraint we have is where we are within the process and the limitations of the model in terms of where it sits right now. So the key elements of that are really alignment with the RPS, how the PDP aligns with that RPS, and changing that approach to how significant risk is defined, how we embed the ES model into the proposed district plan, how do we cover the gaps that the ES model does not extend to cover. So the ES model only covers really the settlements of Gore and Mataura. There's known flood-prone area that isn't included within the model. I appreciate this is late in the process, but I have, for the benefit of the panel, a map just to compare it, and I wondered if I could circulate that.
Can we have a number of copies run off, please, so that there's some available for people at the back? Do about 10.
Thank you. It's more just, and I appreciate it's late in the process, but it's at this end as we move towards sort of having the last consideration of evidence, etc. But it does provide a useful way of illustrating that difference in terms of coverage and how would we address the areas outside the extent of the model. Changes to how significant risk is interpreted or defined. I think, from my perspective, I agree that needs addressing. I just think it needs to be done in a comprehensive manner rather than through some evidence on a chapter. It needs to be done in a comprehensive way where we can consider the policies at the same time, as well as what is the definition of significant risk. And if we're wanting to shift that towards using hazard categories or a different methodology to build the policy framework, then it needs to go through that process, through its due process. So I've summarised my position on the ES submission. I acknowledge the further information that they are providing to support their position, but I think the outstanding uncertainty and limitations of the model and the lack of coverage of known flood areas presents a large challenge. We're not able to incorporate the Tonkin and Taylor model to fill the uncovered areas. It wasn't built for the PDP, and it itself has uncertainty and limitations, which I think is recognised by ES as well. The model also does, the TNT model does not include a 0.5% AEP event to map in with the provisions. I don't support redefining significant risk within the RPS, although I do acknowledge, categories are an improved way of approaching that. In fact, I did flag that in the section 42. And I acknowledge the support of the identified provisions within Appendix 1 of Mr. Roy's evidence, but ultimately reject the amendments to the remaining identified provisions in favour of the recommendations of the 42A report. And in doing that, I just want to pick up on that approach within the section 42A that I have recommended. So it did respond to the original submission from ES in terms of how permissive that chapter was as a natural hazards chapter. It did seek to improve that alignment with the RPS and the policy directions in the RPS. It did that through using the existing notified overlays, the hazard overlays within the proposed district plan, and it aligned those with the policy direction of significant versus not significant. The policy direction has picked up on sensitive activities and distinguished those from non-sensitive activities. The rules and activity statuses and the standards for information required with them has been improved, and what I have done is included a note that attempts to map in the ability for ES to use that model to establish finished floor levels. So it does in not a direct way, but an indirectly way, enable the ability for those outputs from the ES model to still continue to be used through the provisions in the natural hazard chapter.
Would you like to talk us through this map before moving on, now that we have it in front of us?
Yes. So it's very basic. It's very simplistic. It is literally the actual and potential inundation area. So that's a larger, darker blue that you can see from the notified PDP. So that's the extent of flood-prone land identified. The lighter blue is the outputs from the ES model in terms of its coverage.
At which level?
At a 1% AEP event, yeah. So it's very useful for Mataura and Gore.
Yeah, so, but just looking at this, so what we know of what Environment Southland have put forward in their model is when we look at that light blue, we are looking at significant risk.
Not entirely. This is very simplified, so it's literally all categories 1 through to 6.
Okay.
Yeah. It's really just a footprint comparison, not a hazard category
That's what I was
comparison.
trying to get at. So, all right. So what this is showing us is that the ES model is not indicating a bunch of areas as being inundation risk.
Correct.
And is
Yep.
this pattern that you're showing us here common in terms of comparison between the notified PDP maps and the ES model outputs? Is it commonly the case that the PDP maps show a greater extent of inundation?
Sorry, the ES will probably want to expand on this later, but their ES model only captures the Gora Mataura catchments. It doesn't go up to the settlements. So, for instance, in Mandeville, you'll see that the notified PDP maps are showing flood risk. The ES model isn't suggesting there isn't a flood risk there, it just hasn't extended to that area of the catchment.
Right. So that's actually what this is showing us. The
extent of coverage.
the extent of coverage of the model and the extent of coverage of the mapping.
Yeah.
Thank you.
Yeah.
So
Yeah.
the dark blue, what does that show?
That's the actual and potential inundation layer.
But
within
where does that information come from?
That is from as notified, and that is a combination of layers that Gore has built up over time from observed flood extents, from recordings, etc. It's not modelled.
Right. So,
Yeah.
so it's areas that have previously flooded, regardless of the depth, or is there a minimum depth?
It's anything over 10 centimetres. Yeah. Yeah.
And so if we're thinking about Tonkin and Taylor and what they've done, where would they be in this picture?
It's probably best for Mr. Morris to
Yeah.
clarify that, but my understanding is that Tonkin and Taylor have a much coarser model, and it is built at a nationwide scale, so it's not built specifically for Gore District, and it's useful, and I think ES have acknowledged that within their evidence. It's useful to an extent, but it does have inherent limitations, and it's probably best for Mr. Morris to walk through those.
Is it fair to say that each of the approaches, the approach from the section 32 as notified, so the blue area on here, that has its limitations, one of which is it's just observation, it's not models, it's a bit of a cobble together. And then Tonkin and Taylor has got its limitations, coarse but available, and extending over a greater area than the ES model, which is a deeper dive, but in the higher populated areas. Is that a fair summation? But all of them have their limitations.
Yes. I think the ES model would be closer to what you would expect to see today if you were preparing a natural hazard chapter. It certainly is closer to current best practice. The existing layers used within the PDP are based on observations, and they're more a record of historic flood extent, so they don't factor in future change. ES model based on depth and velocity will contain event scales, so it looks at a 1 in 100, it looks at a 1 in 50 potential flood extent. What it doesn't do is go beyond 1 in 100, so it's only a 1% model. It needs to be run again for a 0.5.
So how does the council administer a rule for 1 in 200 year floods when the best available data for part of the district is only for 1 in 100 year?
It is using the layers. So what the panel have in front of them are three approaches. Effectively, you've got an approach where you have the existing PDP as notified with 3 layers in it, and they categorise the level of hazard risk based on areas prone to flooding. That maps to the RPS. The RPS says there is a significant risk from flooding if you are on flood-prone land and it's not protected, from stop banks from flood alleviation works. It doesn't consider a significant risk if that flood-prone land is protected. So Gore is not considered a significant
Sorry,
risk.
That's not what I'm trying to get at. We have a rule that require, well, what's been mapped in the report by ES shows the 2% flood area that in Gore is fairly well constrained. They've also mapped the 1% that goes a lot wider.
Yeah.
The 0.5% would be even wider. So how does the council administer a rule that requires compliance with 0.5% when there is no data available to show it?
Yeah. So to answer that question, a little bit of context, the existing notified chapter contained a rule that set that minimum floor level at 0.5%. So I haven't changed that.
No,
that has continued through.
How does the council administer it?
It administers it at this stage through the provisions within this rule, and that allows the applicants two opportunities, I guess. The first is to go to ES, which is the current sort of process in terms of obtaining, flood information for a property. ES now have a model built for those two key areas, and evidence from, advice from Tonkin and Taylor and Mr. Morris is that to rerun the model can be done fairly simply, and that can provide the 0.5% outputs.
Isn't there another question that's kind of more important, which is the 0.5 actually appropriate when we've got a 1% AEP model indicating that existing stop bank infrastructure will be overrun, and gives us depth in a way that we didn't have.
Yes.
So doesn't that clearly bring into focus a question as to whether that minimum floor level is conservative enough or precautionary enough?
Yes. Yeah. No, that's a fair point, and I think I have indicated that at a point in the 42A is that there is a question around, is the 0.5 still the appropriate measure? And I'm sorry if that was where you were going with that question, but it is true. It is, now that we have a model at least built to 1%, is it ES's position that that would be more appropriate? Bearing in mind that there are variables that play into a model, and climate change hasn't been built in for future intensity, and what level has freeboard been accommodated within that model as well?
And after we've heard from Environment Southland, and the purpose of that question is to flag an issue I want them to talk a bit more about and then come back to you. But are there any submissions that actually enable that figure to be altered?
I'd have to have a detailed look on that specific question. Off the cuff, I don't think there is any specific request regarding, regarding 1% or 0.5.
Yeah, and I think that's the issue that we face in a number of cases. There may not be an explicit reference to 0.5, but there may be a submission in amongst the 100 and something page summary that we've got that actually talks about the level, and so if someone can come back to us, would be helpful.
No, there aren't any submissions. I've just checked. Not that enables us to alter the finished floor level.
Okay. So I guess at the end of the day, what's in your evidence is that you believe there should be a variation or a plan change done, and it would be good if you're still of that view after we've heard from the others that, or did it come from one of the other experts, what that plan change should encompass.
That's right. I mean, I've strongly recommended that this be dealt with in a comprehensive way rather than trying to address that now at this stage of the process. I think we need to be able to build it around that model.
So there's a contrary review obviously put to us, and it has the precautionary factor in it, i.e. what has been brought to the table now for at least Gore and Mataura is the best available information. It is a step up from the Tonkin and Taylor information. It's available to us in this hearing. It's got a submission that's giving it a bit of a korowai to come in. And the you can see that there is some potential risk of delay in responding to that best available information where we've got an opportunity to, i.e. we can't know as a panel how long it would take to respond and develop, or what decisions might be made in the interim. We've got no control over any of that, but we do have control over this decision-making process with the best available information in front of us. So I do feel that we've got quite a strong responsibility to work with that as far as we can go, because it's telling us more than the notified version and more than Tonkin and Taylor's information has been able to tell us. And that I do feel that duty very strongly, and that ES are putting forward a position that the precautionary approach suggests that we should act on the best available information we have now. So in my mind, it's more about working out how we do that within the scope of submissions we've got, rather than deferring for the, you know, the next process. Or I just to let you know that I'm interested in how far we can go with the best available information we have.
Yeah, I think there's a significant challenge here in terms of that we don't have full coverage of known flood-prone areas. So that a significant, which I've flagged in my evidence, is a significant gap in terms of how do we treat that area on that map as I've circulated. If it's not under the ES model,
Yes.
How does that get covered, and how do the provisions speak to those areas?
So that's where your position to us is that we can't rely on Tonkin and Taylor for that because it's got limitations. But what I'm going to ask you is Tonkin and Taylor the best available information when we compare that with the notified Section 32 cobbled together observations? You see, I'm wondering, when I read the evidence of Ms. Patterson for ES, she's talking about these tiers of information and their reliability, and you know, putting the ES modelling ahead of Tonkin and Taylor, and something I will ask you certainly. But Tonkin and Taylor I had in my mind as a step above what was available at the time of notification in terms of best available information. So when I'm looking at those three things, at the moment that's how I'm thinking of it in terms of levels of improvement. So what I was wondering was, what's your basis for saying that we couldn't rely on that course Tonkin and Taylor modelling to fill the gap in the interim until such time as this level of depth of information is available for the wider area?
That's on the advice of Tonkin and Taylor.
There is another issue, and that's what legal liability lies with the council, having been told that here's some information on potential flood levels, and it is relevant information probably for the issuing of building consents, and also in the consideration of resource consents. So how is this new information that actually shows in more detail, that is more reliable than what's in the district plan, what is the appropriate technique to use to actually make use of the information?
Yeah, so that's what I'm alluding to, is that there are 3 rules that I've made provision for to enable applicants to go to ES and use that information in terms of completing the finished floor level. So that's under Rule 3, Rule 5 and Rule 6. Now it is indirect in terms of being able to use the outputs from that model. It's not in the traditional sense, but I'm working within the constraints of a 42 approach here, and within the scope of the submissions. So there's other issues that need to be traversed, obviously, in terms of the legal subs regarding scope, and where we are in the process and the extent of the model as well. What I'm proposing is that I agree that you want to use the best information you have available. ES have not provided how that could be achieved, and it might be that through evidence today we might see how that could be achieved and might take that conversation a bit further. But at this stage, based on what I've seen, I haven't seen how it can be mapped in.
Does the present model just identify an applicant or a resource consent should then go to ES for further information? Because I'm guessing the overlay is the same, it's just the depth and magnitude of it changes. So
Yes, I mean, essentially how it's tackled is there's a note that enables them, to seek that technical advice from ES, depending on which overlay you're in. So there's 3 overlays. And like I say, they've mapped into the RPS. So the highest risk area is the Mataura River floodway. And the advice is that we should avoid any, development within there. It needs to function in terms of dispersing flood water, and it's very high risk. Within Gore itself, that's predominantly covered by the stop bank protection overlay. It's a protected area, and in terms of the RPS, it's not considered a significant risk, but it is prone to flooding. So mapping through that rule, you would be able to go to ES, receive what sort of flood risk you would be getting from the model, and that would help inform your finished floor levels, etc., for new development. What I think you need to bear in mind, and part of weighing up how we incorporate the model, is the other half of the evidence from ES, which is also saying that effectively the risk within Gore is too great and it should be non-complying as an activity status. So while you bring in the model, really the redefinition of significant risk from ES is that only category H1 and H2 would be restricted discretionary. There would be no permitted level, no permitted activity level. And for the most part, most activities, any new development would be non-complying, which is a very high threshold. The provisions as amended within the 42A strike a balance. They're trying to recognise that there is established development within this area and trying to weigh up whether it's sensitive or not sensitive to flood risk based on whether it's a residential use or not, and seeking to promote mitigation around raising finished floor levels. Is evacuation safely achievable? It's not a perfect approach, but it's a balance between the two, using the existing chapter and the scope of submissions to straddle that challenge. But that's why it informs my view that to comprehensively address the recommendations of the ES model is to look at those hazard risks and have a better conversation and a better analysis around what are those hazard risks and where should those activity statuses sit and how does it map back, because we're still stuck under the RPS that is beyond challenge. The policies can't change. It's binary. It's either you're significant or you're not.
I hope you brought your crystal ball with you, because on one hand we've got a map with historical data and flooding, so I'm picking that a lot of the modelling is a projection of what the impact of climate change might have. No?
No, climate change hasn't been incorporated into the ES model.
Thank you.
Can I just ask, in terms of the map, the paler blue, would it be fair to say that there's more stop banks in that area, and the darker blue would be more sensitive as a hazard?
Generally speaking, yes. The stop banks are predominantly around Gore, and you know sort of where that infrastructure is, and again around Mataura, both across to the west as well as the gorge itself.
So that area, I'm trying to figure out where that area is that?
Oh, that's an extension. I think that's the Waikaka.
Yeah, that's Waikaka. It's sort of
Oh,
the
and
flood
it's-
inundation. The dark blue is basically what's in the PDP now, just as a overall layer.
Right. Thanks.
So in terms of council's experts availability, Mr Morris from Tonkin and Taylor is our flood engineer, and he is available from 20 past 10 today. He'll be watching, but he is available for questions should the panel, at any point arise.
The question, pretty straight. It's one that I'd like to ask if he is available. And it goes to what you were saying before in terms of what you've presented to us is a comparison between the notified version and the ES model. I want to understand as a panel, how should we be using the TNT advice? That's what I want a basic understanding of, because previously we've had some TNT advice that fed into our thinking around the development areas in industrial areas in earlier hearing. We really need to know in what way we should be relying on that evidence and how we should be utilising it in decision.
Is he online?
He's watching on YouTube, but he'll be hopefully logging into Teams shortly. I think his availability was pretty much from now onward, so might just... while we're waiting for that to happen, I did just quickly look, or Nicole in the background looked at those submissions that you asked about earlier, in terms of those 3 further submissions from Contact Energy. We've double-checked the original further submissions, and that is correct. They made an error in their further submissions of further submitting 3 times on the same provision. So the one that they're under is the one that they're providing a further submission on. And then just going back to the critical infrastructure versus regionally significant infrastructure. So I've had a look at the updated sort of master copy of the plan that we have, which reflects all the changes that have happened. So now there is only one reference to regionally significant infrastructure in the earthworks chapter, and Tina has confirmed that she's comfortable for that to be amended to critical infrastructure. So that's within earthworks policy 5.5.
Just in terms of timing, I see now the intent of us having a break starting at 10:05 was because someone was coming online at 20 past, and we weren't aware of that. So that's why we've kept going, and it's now 20 past. And I was proposing to actually take a break at 10:30 prior to hearing from Environment Southland at 10:45. So who is it that we've got coming up online?
Tim Morris, he hasn't actually texted me back yet, so maybe if the panel would like to, I'm sure we can adjourn and he can come in later.
We'll need to deal with him then after Environment Southland. And probably so that there's some certainty, let's do it at 1:15.
Sure.
And given that it's 25 past and we've got 20 minutes until we hear from Environment Southland, we'll now take our break. I think that's a good point now, and to have. So we'll adjourn until 10:45. Thank you.